Good afternoon. This is Judge Elisa Bettis presiding over the 210th District Court criminal docket for July 9th, 2024. All matters being heard today are being heard in accordance with all all directives regarding remote proceedings. In addition to that, we are streaming all matters live via YouTube. Mr. Nunez, please go ahead and call our first case.
Yes, ma'am.
I'll call it. Calling cause numbers 2024-0D02834 and 2021-0D02928, State of Texas versus Kim Arlene Hugendorn. May I have announcements, please?
8-1A for the State of Texas. Present ready, Your Honor.
Good afternoon, Your Honor. Jose Montes for Ms. Hugendorn, ready.
And Ms. Hugendorn is appearing remotely from the jail annex. We are scheduled for bond hearings in both her cases. I believe our last setting was also a bond hearing, Mr. Montes. If I'm not mistaken, maybe we might have waived it because I did see that on the 2021 case, she's still at no bond. Right. And then on the 2024 case, I'm showing her bond being $13,500. Is that what your records reflect?
I think that's correct, Judge.
Okay, you may proceed.
Your Honor, I was reappointed on these cases when Ms. Hugendorn was rearrested for a first-degree felony, manufacturing, delivery, another possession of controlled substance, a third-degree felony, and a state jail felony for possession of controlled substance. Your Honor, it was a big surprise when I was appointed because Ms. Hugendorn, at the time that she pled, was doing very, very well. She was staying in touch with me by email, by phone. She readily read and signed the plea papers and was on her way. Obviously, she had a drug relapse and episode. Ms. Hugendorn today looks remarkable compared to her arrest photo. If the court would look at the portal,
I have.
She looked, awful, and she looks restored. And my point being, Judge, is that she needs medical and mental health treatment, not incarceration. I think she's going to live at 6001 Dyer Street, El Paso, Texas, 79904, unless I stand corrected. Ms. Hugendorn, where do you plan to live if you're released?
It's 3731 Fred Wilson, apartment number 1.
Will you be working?
No, I have a full-time and a part-time caregiver. I have survivor benefits that I get each month for my dad passing.
Thank you. Your Honor, pass the witness.
Well, I mean, she hasn't been sworn in.
Oh, yes, Judge. That's all.
I'm sorry?
That's all we have, Judge.
Ms. Wineria, do you have any questions for Ms. Hugendorn?
No, Your Honor.
Okay. All right, Ms. Wineria, you may proceed.
Thank you, Your Honor. Ms. Hugendorn probably is benefiting right now from being incarcerated. Again, based on, like defense said, her book and photos, she has a history of drug abuse. Her rap sheet consists mainly of manufacturing, delivery, and a possession. Now, it's one thing if it's just possession, but the fact that she's also manufacturing and delivering to others creates an issue for the community. She has some things in her past that have shown that she can be a threat to the community. She had a bank robbery that she was incarcerated for. And I think, without some parameters set in place, she's just going to fall back into what she's done before. Now, the state doesn't, we don't think that she should not be bonded out. We just believe that the bond is adequate based on her criminal history and based on the threat that she could possibly pose to the community. So we would ask that the bond remain in place, but if the court sees to, lower the bond, that she be given restrictions like weekly reporting to make sure that she is compliant with any sort of restrictions in regards to drug or alcohol use.
We may have heard that bond, Mr. Montes. I'm just seeing, I don't know why I was thinking she was on deferred. She wasn't on deferred.
No.
She's got the conviction. I'm looking at a PSR that starts in 1996 with possession of a controlled substance, and it's 17 pages long. Bear with me 1 second. Is there a rec on the 2024 case?
Not at this time.
Are there any co-defendants on the 2024 case? While you're looking at that, Miss Pineda, are you there? Do you show that she's ever received something like BHRTC or some type of intensive treatment or anything of that nature in any previous local cases?
Let me check on that.
Something up here. Frankly, I'm not comfortable leaving her on probation, so that kind of factors in to what I think the bond should be. I can tell you her original bond, I'll tell you this right now. On the new case, there's no way, due to the prior history, the safety of the community, that bond is getting low. And I understand, Mr. Montes, she may not have any resources. Okay, so that might as well be, $130,000. I don't know.
Right.
On the probation case, when I went back and looked at it, she was originally on some 30,000 before she pled, a $30,000 bond. Then she was PR bonded. She pled. Trying to think if she pled when she was in custody. I'm not really sure about that one. But I wouldn't go under $30,000 cash surety. I agree with the state in terms of she looks a lot better now, but it's because she's in custody. So let me go back and look at the PSR. 96 Monday.
I apologize to interrupt. I don't see that she's been on probation in the past.
Has she ever been to prison?
She she has something out of the federal system for bank robbery.
What's the time on that?
Let me-
What's the year on that? I'm going to start on my PSR 96. We have controlled substance, dangerous drugs. Looks like that was dismissed. Eugene Police Department in 96 again. Forgery. 96 again. False information, making a false report. This is all Eugene. Possession, controlled substance, dangerous drugs. It doesn't give me a dispo. Then I guess we jump to 2008, unlawful possession of methamphetamine, controlled substance offense, reckless driving. 20, let's see, is this the same year? Another controlled substance offense, unlawful possession of heroin. 2008, Lane County, false information to an officer, unlawful possession of heroin, unlawful possession of cocaine. These entries are strange, 90 days jail time, but it doesn't tell me, and maybe those are the sentences for the previous offenses. 2014, first degree theft. That's in Eugene. When did she move to El Paso? When did you move to El Paso?
In 2019,
19?
yes.
So you moved to El Paso in 2019, and in 2021, we get our first criminal case here, manufactured delivery. So that's what she's had here. She comes to El Paso and picks up the cases for which she's on probation.
In 2008, she was charged with bank robbery and sentenced to 30 months.
Yeah. We need to find a number. Her bond on the 2021 will be $30,000 cash surety, and the bond on the conditions there will be to be compliant with probation. I'll commit no new offenses, all of those things. And then in the 2024 case, the request to reduce bond is denied. Do we have a number? I'm looking at we've got a third degree. What, Carla? Let me see. I have too many things open here. The case summary in terms of her performance on probation. setting aside the new offenses. Let me go back to the case summary. Do I have a case summary? Did we have a case summary on Ms. Hugendorf? I know it was a bond
Yeah.
hearing.
I
My-
do, Judge, you know what I think I did? I just realized. I attached one duplicated another one, and I didn't give you this one. Sorry. Hold on. Sorry.
Let me
And
look
Your
at,
Honor, if we're gonna run the probation revocation with the new case, it would be 5 TDC.
let me look at the case summary, Mr. Montes, so we can see what we're really talking about. I feel like I read it once before, but I certainly don't remember it right now.
Yes, Judge.
Mr. Montes, what ties does she have to the community? I mean,
Ms. Huguenot, do you have any family here right now?
No, my son-in-law is in Arizona, but yeah, I know that my record doesn't look good on paper, but I'm in.
Ms. Huguenot, no, that's for later.
Okay.
Hold on.
And Your Honor, if she is released on bond, my only concern is that the apartment that she said that she's going to return to is the same exact apartment complex where the 2024 case originated out of. In that case, it was apartment number 9, and she said that she's going to return to apartment number 1.
Right.
Carla, if you see the report, I don't have it yet, but can you
I
just
just
tell me?
emailed it. I just emailed it to you, Judge. But as far as probation goes, she had failed to report for September and November 2023. She was assessed a TAP assessment back on, let me give you the date. 1/13/23.
Can you hold on a second? What is that noise?
Judge, they're working on the courtroom, moving our light switch.
All right, go ahead. I'm sorry, Carla.
January 2023, she had her TAP assessment and she was recommended no treatment at the time. She failed to report September and November 2023. She was referred to recovery support groups, but she stated she didn't feel any at the time. She was not assessed hours. And then we come January 31st, 2024, and that's when she picks up the man delivery and the other charges that are
Was she-
pending.
Was she ever tested?
Yes.
That, Your Honor, is
Hugendorf, I'm not asking you, I'm asking probation. Go ahead, Carla.
there. Let's see. The last entry I see in the system, Your Honor, is from 12/16/23, and it says failed to provide. 10/19/23, it says failed to provide. And then before that one
Does
is
that mean
7/12.
she didn't, does that mean she didn't report for testing?
Correct.
Okay.
And then on 7/12/23, which is the other one, it says invalid swab. But that's the only information I see, Your Honor.
Is that in the case summary or are you just looking?
No, I had to look it up, Judge. It's not, none of that is in the case summary.
Yeah, I'm gonna need a complete case summary at some point on Ms. Hugendorf because it sounds like, Mr. Nanias, I need you to let them know to be quiet. If you would please just, for our next setting, have a complete case summary with all of the non-compliance. You know, Mr. Montes, we're talking about 5. I don't really feel like I have a complete picture. I mean, I think I do, but you know, if we're gonna look at things that, you know, there's more to put into the mix here. So for now, that'll be the order on the bond and we'll go to our next setting.
Thank you, Doctor.
Thank you very much. Thank you, ma'am. All right. Mr. Ivy will take care of your case next. And then we'll take care of Ms. Nava. We need Kavika Johnson, and I believe there were some folks. Are you calling witnesses, Mr. Ivy?
No, it's just his mom. She wanted to be present.
Okay, that you can instruct them that they can watch on YouTube. We will not admit them to the hearing here. Okay, I didn't ask them to leave because they were not, we didn't ask, I didn't know if they were going to be witnesses in your hearing, okay?
Okay, Judge.
All right, calling cause numbers 2024 0D0 2454 and 2022 0D0 5140, State of Texas versus Kavika Rashawn Johnson. May I have announcements, please?
8-1A for the state of Texas, present ready, Your Honor.
Ben Ivy for Kavika Johnson.
And Mr. Johnson is appearing remotely from, looks like, the downtown jail. We are set for bond hearings in each of these cases. I do see on the 2022 case, there's no bond. The theft case, oh golly, I thought I had written the bond down. I did not. Do you have the bond on that one, Mr. Ivy?
No, I'm sorry, Judge.
7,500.
Okay.
I'll just say on the front end that when I reviewed this and I reviewed the PSR, Mr. Johnson is on probation for the assault on a security officer. The date of offense on the theft case, I believe, is June 2nd, 2023, although it didn't get indicted until May 1st of this year. The problem was, Mr. Ivy, is that he had not been compliant on probation. He left El Paso, he failed to report UAs, BAs, and then was testing positive when he did test. So you're here on a bond, I'll hear you.
Thank you, Judge. My client does live in El Paso. His residence is 7950 Hermosillo Drive, 79915. He lives with his wife, Lucy Weirnicki, Weirnicki.
So Mr. Ivy, just so you know, I think she was also logging on here. So again, can view via YouTube. Actually reviewing the theft, I think she's the person who allegedly the Facebook page was, you know, the alleged stolen property was placed on or advertised on Miss, I can't say the last name's Facebook page. Go ahead.
Okay. I'm sorry, I'm just telling him to log on to YouTube.
That's fine.
He is currently employed, Judge. He works at Top View Fitness and is a personal trainer. Works from Monday to Saturday, 7 a.m. to 8 p.m. So, Judge, he did leave El Paso County. His mom, who used to live in Las Cruces, asked him to come up to Dallas. She moved to Dallas to help her move. So he did go to Dallas. Obviously, it was a mistake. He should have not gone without permission, but he did tell the probation officer that he was going to Dallas for the weekend. He did not get the permission, so that's why we're here for the violation, Judge. And he's only gone for 2 days. You know, it just seems like a warning would have been sufficient as far as that goes, Judge. He was not trying to evade anybody. He's been reporting as instructed. And
No, he's not testing. And then when he does test, he tests positive. So he's not compliant with his probation. I mean, even if I could look away from this, you know, little 2 or 3 day trip he took to Dallas, he's not compliant.
Okay, I guess I don't have that report where he wasn't compliant, Judge. Mr. Johnson, how long have you been in jail so far? If I may ask him.
This will 2 weeks now.
2 weeks. I believe, Judge, that 2 weeks is sufficient for him to learn his lesson. He is only on 2 years deferred probation. And I understand that he has some violations, Judge, but I would ask that you at least give him a bond since he is on deferred on this case. And that's all I have.
All righty. If I remember, the PSR isn't remarkable. I think what we have him on probation for is is the extent of his history. All right, Ms. Winnery?
Your Honor, the state would contend that the warning was probation. That probation having to give him a warning because he broke the rules that he agreed to is not a sufficient argument to the state. Probation is the warning that if he continued down the path that he was going, that he would end up in prison. So I don't understand when defense says that a warning probably would have been more adequate. He's on his warning currently. So with that, he's on probation for assault on a security officer, and then he has a resisting arrest, search or transport, that is still in a P-file status. So I don't know what's going to happen with that, but he does have this theft of property. So all of the crimes that he is committing are crimes against citizens of El Paso. So because of that, we feel, and because he was given an opportunity to correct this path with deferred, knowing that when you sign up for deferred probation, it's not just 2 years, it's 2 to 10. You were looking at the entirety of what you were, in essence, being charged with. So with that having been said, he still goes and commits theft of property, and the state feels that the bond that is issued for the assault on a peace officer is sufficient. And if, he had taken that warning seriously, he wouldn't be where he is today. So we would ask that the bond remain the same, and that whatever bond is placed on the 2024 case, that it not be a PR bond.
Let's see. So he pled in January 2024, right?
Correct.
What are we gonna do about the drug use? That's what I want to know.
Judge, I'm confident he's going to stop it, and there's no use, no tolerance for drug use in this court. I understand that, and Mr. Johnson finally does understand that. He's been sitting in jail thinking about that. He's had plenty of time to understand that, but it's not tolerable. Even if it's allowed in another state, he is not allowed to use drugs in this court.
Mr. Ivy, his parents or whoever it is keeps logging in, and I've messaged them that they can view it on the YouTube channel, just so you
Okay,
know.
yeah. I've
They're
told
not-
my office to tell them also, Judge. I apologize.
Thank you. Is there a rec on the theft case?
Not at this time, Your Honor.
Okay. So in terms of, I'm not sure I'm considering it reoffending while he's on probation. When the date of offense predates his plea. So,
Correct, Judge.
So we're not doing that. Mr. Nunez, if you could continue as they log into the waiting room, inform them that they can watch on the YouTube channel.
Yes, ma'am.
But I also don't think that, I think we're under 2 weeks as of the docket date. He's got 8 days in. I'm not looking at the billing. Because what it looks like to me, Mr. Johnson, is you just think probation is do what you want, not do what you're told, okay? That's not the agreement when you took 2 years deferred. So the amount of time that he has been in is not sufficient. Carla, have we had any kind of assessment with respect to the drug use? I don't recall there being a recommendation there.
Your Honor, Mr. Johnson was referred to TAP for an assessment, and he was admitted to TAP. However, since admitted, Mr. Johnson had failed to attend group sessions for the week. This goes back to 5/27, 5/20, 5/13 of 24, and individual sessions on 6/20 and 5/21 of 24.
So he's failing to go to the treatment, and then he gets arrested on the new indictment. Okay.
Correct, Your Honor. He wasn't attending TAP outpatient successfully.
Okay. So in terms of this is where I'm headed, Mr. Ivy. Obviously, you're representing him on both cases. You'll work through that theft. The bond there, He has, I mean, he's got family, he's got some resources toward a bond.
He does, Judge. I was for a $2,500 bond if possible.
On the theft case or,
Let's see, the theft case is no bond right now, is that right?
the theft case is 7,500 cash surety, and then he's on no bond on the probation case.
Correct. So, if you could do, let's see, 10,000 total.
Okay.
I think you could do that.
So on, well, if that's the case, here's what we're gonna do. The bond on 2454 is gonna stay the same, 7,500. And then on his probation case, I'm going to release him on a PR bond with conditions that he, follow the probation, but he's gonna give me another 10 days as a condition of probation. Not the time that he's been in, he's gonna give me another 10 days. There's no trips to Dallas without permission. There's no missing tests. There's no not going to treatment. That's where I am on the probation case. If
Okay,
he
Judge,
then,
it's definitely better than a revocation, that's for sure.
if he then complies with his probation and we can identify some of the problems that are maybe making him make bad decisions, right? Then we can maybe wrap some things up together, but for now, that's gonna be the sanction. Do we have a trial track already on his 2024 case?
I think it's still P file, right? Maury?
Right now, the only thing we have is the bond hearing for today.
Yeah, so we need to get a trial track on his theft case. I gotta think, well, I don't know, might not be that quick of a turnaround. It looks like that investigation was kind of piecemeal. So we'll just get you a trial track on the 2024 case, carry his probation case along with the new case and see, we can do 10,000. Hold on a second. No, we should probably do, 10,000 is fine on the PR bond. And then we'll see if he shapes up on probation and things get better or not. Okay,
Okay, Your Honor, thank you.
thank you very much.
Your Honor,
Monday.
before Mr. Johnson leaves, or if Mr. Ivy, may I address Mr. Johnson and remind him
Yes.
to report to his probation officer?
Yes. Mhm.
Okay, Mr. Johnson, please report to your assigned probation officer, Ms. Rivera, okay? When you get released.
Yes, ma'am. May I say something real quick?
Mr. Ivy, are you good with that?
Just don't talk about your case, and I'm fine with it. Just don't talk about the pending cases, okay, Mr. Johnson?
Yes, sir.
Okay.
Go ahead.
Your Honor, I just want to say that I have first the utmost respect for my CO. I have the utmost respect for you, Judge Perez, and I never meant to make any mistake in here. And this is my first time on probation, and I was trying, and I have 3 jobs, and I was working, and I know on paper it may look as if I'm not being compliant, but I'm doing everything in my power, Your Honor, to do what I need to do, and I just want to say I am sorry for this, and I'm not a menace to society or anything, and I do plan on making better decisions.
Okay, I hope so. Alrighty, thank you, Mr. Johnson.
Thank
All
you.
right, Mr. Ivy, we'll get you your settings so that you have a trial setting on the new case.
Thanks, Judge.
Have a good day. Do we have anyone else downtown?
No, ma'am. That's all we have downtown.
Thank you, downtown. Have a good day. Miss Nava, your client is, I know I had it right here.
Mr. Allen.
All right. Annex, could we have Darian Allen, please? Oh, I had it queued up.
Come in, Your Honor.
Thank you.
Afternoon.
Good afternoon. Calling cause number 2024-0D00155, State of Texas versus Darian O'Neill Whiting Allen. May I have announcements, please?
Ada Waneri for the state of Texas, present ready, Your Honor.
Alyssa Nava, on behalf of Mr. Allen, Your Honor, we're ready to proceed.
For purposes of the record, Mr. Allen is appearing remotely from the jail annex. We are set for a bond hearing. Ms. Nava, I have him at 40,000 cash surety. And if I'm not mistaken, he was out on PR on some other offenses, and then he picks up these new charges. So go ahead.
Yes, Your Honor. So all of these charges are related to the same complaining witness, the mother of his two children. We do believe that there are credibility issues when it comes to the complaining witness. I will explain a little bit of that as I go through Mr. Allen's history. He is a United States citizen. He was born in Austin, Texas, but has lived in El Paso for about the past 4 years. He has two sons with the complaining witness, a 5-year-old and a 2-year-old. He has had several jobs with the government. He worked with the Texas Department of Criminal Justice from 2017 to 2019. He worked with juvenile probation until about 2021 when he was working with CBS. Once all these charges came about, he did resign. He has a bachelor's degree in communication and was working with customer service prior to being incarcerated on this current charge. I have been in constant contact with his mother, who's very supportive and wants to do everything to help him and to make sure that, you know, he succeeds in life. The offer right now is probation. We are asking for his day in court at this time based on things that we've learned throughout our investigation. This offense itself, Mr. Allen has the majority of the injuries, to include a visible bite mark where you can see the teeth. It looks like he's also been stabbed. It's our contention that DCW was actually the aggressor in this situation. Mr. Allen does have some stuff when it comes to mental health. He's working on that though, and there's also an issue when it comes to accessing certain evidence that I need. So there is some evidence that he has on a cell phone. However, he's unable to access that unless he gets out and is able to start paying his phone bill. He is unable to afford anything, though I do understand with the charges, he needs a very low cash surety bond if the court is willing. We'd ask that there be a no contact order with the complaining witness. He would abide by that. And we're just asking for the opportunity to be able to prepare for trial while he's out of, or not incarcerated, rather.
I misspoke, Ms. Nava, and thank you, Jasmine, for correcting me. This was a $60,000 split bond, 30/30 at jail magistrate, and then I've got to say it was me that lowered it to a $40,000 split bond, 10,000 cash surety and 30,000 PR.
Yes, Your Honor, I do believe that is correct.
Let me ask you, Ms. Nava, you mentioned this is, it sounds like it's a trial case. Are you otherwise ready for trial on August 30th?
Yes, Your Honor, I'll be ready.
Okay, all right. Ms. Mary, go ahead.
Your Honor, it seems that the defendant has a history of violence when it comes to this particular complaining witness. The case that he's seeking bond for today was pretty egregious in and of itself. Officers arrived on the scene because the complaining witness had to text someone outside of the apartment to get help. She was unable to make any phone calls or do anything like that. She had barricaded herself into a bathroom at one point, and at another point, witnesses were trying to intervene while the defendant was assaulting her. So with that being said, the complaining witness has gotten an 8-year protective order in place, but there's only so much that can do. So the state believes that the defendant would still be a threat to the complaining witness in this case, and we ask that the bond remain as is, especially with his trial date coming up rather quickly.
Ms. Nava, do you have anything else?
Yes, Your Honor, in regards to some of the accusations of violence, the initial accusation that the CW made was based off the fact that she believed he was cheating on her, and we believe that she did this as punishment to make these accusations. But again, we still believe that she's the aggressor. He will stay away from her as he does not want to deal with any more charges and just wants to be able to fight these from outside of incarceration.
Yeah, unfortunately, I think when I reviewed your client's history and the case and the bond, my head was exactly where it actually ended up being before, which was at a 10-30 split on a 40,000 bond. So that's what it is. The request to reduce bond is going to be denied due to the nature and circumstances of the offense and safety of the community. I want to just emphasize, that trial date is, coming up here pretty quickly. Be ready, because we will readdress the bond if for whatever reason there's any request to delay.
Absolutely, Your Honor, I'll be ready.
All right. Thank you very much.
Thank you.
All right. Who's next? Do we have any other attorneys? Oh, Mr. Huffman, sorry.
Hi, Judge.
Hi, who are you here on?
Arturo Woodruff,
That's correct.
page 11.
Annex, could we have Arturo Woodruff?
Yes, Your Honor, it's coming up.
Thank you. Alrighty. Calling cause number 2024-0D02554, State of Texas versus Arturo Woodruff. May I have announcements, please?
Ada Winary for the state of Texas, present, ready, Your Honor.
Rick Hoffman on behalf of Mr. Woodruff, we're ready.
And Mr. Woodruff is appearing remotely from the jail annex. Is that your client, Mr. Huffman?
Excuse me, Judge. Give me. Yes, Your Honor.
Okay, you may proceed with your bond hearing.
Thank you, Your Honor. Judge, Mr. Woodruff has been in custody for a little over 2 months on a $30,000 bond for this alleged aggravated assault. He is a United States citizen. He has lived in El Paso his whole life. He does have all of his ties belong in El Paso, Judge. He has a mom here, an uncle here. I have an address listed in El Paso that he says that he's lived at for the past year. The zip code being 79907. He's willing to provide that address to the court. He works, Judge. He does side jobs. He's been trying to get into the workforce. He's been found to be indigent, Judge. He doesn't have any money. His family and friends don't have any money that they can give him towards the bond. He's receiving benefits from the government. He does receive food stamps. He does suffer from some mental health illnesses, and he is receiving services outside the jail. He's been on PR bond, Judge, for a few months before he got arrested, and it's my understanding that he was compliant with the conditions, other than this new arrest, these new allegations. But we definitely want to get in front of the court, Judge, and request a bond reduction. We know we can't get a full PR bond for this type of offense, but we would ask the court to significantly reduce the bond to something that he might be able to afford, Your Honor.
And I am now seeing it's not on the docket, but he has 2 additional felony cause numbers, 2024-0D00929 and 2024-0D01137. Okay, let's see. That's a drug case. And then 1137 is, do all of these, do they have different dates of offense, Mr. Huffman?
They do. And he's on bond. He's still on PR bond. Those PR bonds, I believe, are still intact. So he's only being held on the aggravated assault right now.
I don't know why those PR, did the aggravated assault happen after yep.
It's alleged to have happened in May, Judge.
So the ag assault is in May, so PR bond just hasn't caught up with him, right?
Correct.
All righty. He's got an extensive criminal history, Mr. Huffman. Okay, Ms. Winery, go ahead.
Your Honor, the defendant has been convicted of aggravated assault with a deadly weapon twice before. In this case, he went to a food truck where other people were present with their families to have meals, and he decided to get into an argument with one of the workers at the food truck and attack him with a machete. The worker was able to attempt to defend themselves with a knife, but a pocket knife versus a machete, it's like a gun to a knife fight. So with that being said, Your Honor, with his previous criminal history, having been convicted of aggravated assault twice before, the state would contend that his bond remain where it is and that it is adequate for the situation and that it not be lowered.
How many times has he gone to TDC?
Let me check on that one really quickly. He's been to TDC. He went in 2009, in 2010, which maybe, no, he went in 2009. He was at the Middleton unit in Abilene. In 2010, he went to Huntsville. In 2016, he was paroled. In 2022, he went to Huntsville and he was discharged from Huntsville in 2022.
His bond here is 30,000. The request to reduce bond is denied. Mr. Huffman, I'm going to pull his PR bonds. Ms. Hernandez, if you will contact PR bond to get violation notices. I'm not sure if they've just overlooked this on the other two cause numbers for which he's on bond. You can anticipate those bonds will be at $100,000 each. You do have a trial track, Mr. Huffman.
Thank you, Your Honor.
Get to work. It's not that far down the road, Mr. Huffman. It's October, so.
We'll be
Okay.
ready, Your Honor. Thank you.
Thank you. Thank you very much.
May I be excused, Judge?
You may. Have a good day. All right. So we're missing some folks. We can get off of YouTube if we don't have any other attorneys. Well, Mr. Lozoya is going to need an attorney if I'm not mistaken.
Yes, ma'am.
Murna, does Josiah Lozoya have any, how do you pick? But I don't see any attorney on here. We're gonna need to get him a court-appointed attorney. Well, no, Mr. Huffman's gone. Hi, Ms. Chavez.
Hello, Judge. Good afternoon.
Good afternoon. How are you doing?
Pretty good. Thank you for asking.
Are you here on Mr. Lozoya's case?
Yes, Your Honor.
Let me
Hold your hands on
Yes.
Just wanted to let you know on the case for Mr. Lozoya for 2023-0D04092, he has a waiver of the appointment of counsel he intends to hire, and that's dated July 2nd.
Oh. Okay.
It
Okay,
does
thank you.
include all the cause numbers on there.
Okay. It does not?
It does.
Oh, it does. Okay. Annex, let me go ahead and have Mr. Lozoya then.
Coming out, Your Honor.
Thank you. Who was his previous attorney, Myrna? I thought it was Mr. Olivas. Was it Mr. Olivas?
Jesus Olivas, Judge?
No, I don't know. Let's go ahead and appoint the public defenders on Mr. Lozoya's cases. Mr. Lozoya, good afternoon.
Good afternoon, ma'am.
Sir, you have several cases today and the probation officer is here. We're set for probation status hearing. I'm going to appoint you an attorney, okay? I don't want you to be here without representation. So it may mean a delay of about a week. I'm going to try and reset you for a week. I'm going to appoint the public defender's office. Well, hold on. No. I'm ignoring what you just told me. Mr. Lozoya, my staff is telling me whenever they did your intake this last time, you indicated you did not want a court-appointed attorney, but you were going to hire your own attorney.
No, ma'am, I believe they had told me I was appointed an attorney. I heard it was a female, I believe. Did go ahead and get in contact with her as well.
An attorney? You
No, that she was appointed, I believe she was appointed from the state's pro bonos. But
Okay.
I don't remember waiving my rights.
Okay, so here's what I'm going to ask my staff to look into that. Maybe we're missing some order from the jail magistrate about an appointment. If I don't see one, I'm going to appoint the public defender's office, okay?
Yes, ma'am.
And then we'll go from there. I don't want to get into any of the details without you having an attorney, okay?
Yes, ma'am.
All right, so Myrna, if we can fit them in on next week's docket, we will. If not, it'll be 2 weeks out. In any event, you'll get your attorney as soon as we figured it out. We'll get you an attorney appointed. All righty?
Yes, Your Honor.
Okay, thank you. Are we, Ms. Chavez? We'll see you at the next setting on that one unless you have something else.
No, that's it. Thank you, Your Honor.
Thank you very much. On Mr. Valdivia? Have we heard from Mr. Barra?
I called his office to see if he would come back on, Judge.
Oh, he was here? Okay,
He was here and he logged off, and I just called his office again.
okay. On Ms. Winery, on Valdivia, on Lozoya, we have a new ag assault? Is that what it is?
Hosea?
Uh-huh.
Assault on, I don't know.
On June 6th, Mr. Lozoya was rearrested for the following offenses: aggravated assault with a deadly weapon and criminal mischief. So if you'll maybe request intake and see what's going on over there.
Okay,
Okey doke.
I will do that.
All righty, thank you.
Mr. Parra's here, Judge.
Annex, could we have Mr. Valdivia, please?
Coming out, Your Honor.
Thank you.
Hello, Your Honor.
Hi, Mr. Parra. All righty. Calling cause number 2018-0D06090, State of Texas versus Julian Rene Valdivia. May I have announcements?
81 area for the state of Texas, present ready, Your Honor.
Manuel Parra, Your Honor, for Mr. Valdivia, also ready.
And Mr. Valdivia is appearing remotely from the jail annex. We are scheduled for a revocation hearing today. Let me pull up the case summary. Ms. Carla, do you have the case summary handy?
Yes, Your Honor. Your Honor, Mr. Valdivia is, the last couple of hearings, we've addressed that, he was at BHRTC and absconded from BHRTC.
Mhm. Okay.
There was also a previous evading arrest,
Mhm.
from 4/26/22.
Mhm.
And that's when he was modified.
We were at 4 TDC. Mr. Parra, did you just get hired on this case or?
Well, Your Honor, I haven't been on it very long.
Right.
He has, I was able to do a bond hearing for him, Judge. You might remember my pointing out that he's on deferred adjudication and as such was entitled to a bond. I think Your Honor said it at that point at $100,000, Judge, cash or surety. He has been in custody, Judge, since January 13th. I'm not sure if that's something we can at least reconsider at this point, Judge, but it's our hope that he remain without a felony conviction and that he be allowed to go back on probation. I mean, this could be treated on commitment, or at least, Judge, let him out on bond to show you that he can complete the conditions and comply with the court's orders.
No. When you abscond from BHRTC, when we're already trying to do it, pretty much what's at the more serious end of treatment and you run, you're getting time. So I need to know if you need a contested revocation, Mr. Parra, or if your client is going to accept the 4 TDC.
Judge, I think we would need a contested revocation then, in which case, Judge, I request additional time, Judge, to gather some witnesses to testify on his behalf.
Will 30 days be enough time?
I expect so, Your Honor.
Okay, we'll set you for an in-person contested revocation in 30 days. Okay,
Understood, Your Honor.
Your Honor,
thank you very much.
Oh,
Yes, ma'am.
just if I may remind the state, I don't see that there's an updated motion filed, and the probation case is set to terminate on 7/15 of this year.
Oh, we need that like yesterday.
Right, we will
Because
get-
there had been a prior MTR file for the previous, when he had absconded at some point back in 2021
Thank you,
and
Carla.
2022.
In addition to the 30-day contested revo, we're gonna do a status hearing on Thursday. Mr. Parra, it's obviously we can utilize it as a regular hearing. It's my intention to use that as a marker to make sure we have our motion filed. Okay?
I'm sorry, Judge, this Thursday?
Yes, and it'll be Zoom, like I said. I know you've spent a lot of time in the 210th this week already. It's really just for the court to follow up with the state. But absolutely, we can utilize it if you need that time as well, okay?
Understood, Your Honor. Yes, ma'am.
Thank you very much. Thank you, Mr. Valdivia. All
Good
right, take care. Is that everybody?
Yes, ma'am.
Annex, thank you very much. Have a
Sure.
good afternoon.
Your Honor, we still have Davila Eduardo.
Oh, I thought that was
Mr.
everyone.
Morales is on vacation.
Okay.
Page,
All right, Mr. Davila's attorney is on vacation, so we're gonna need to reset him. Is there any concern on a timetable, Carla, on Mr. Davila? No, I can reset him 2
No,
weeks
Your
out.
Honor, no, the probation department's recommending BHRTC, but
Okay,
let's see.
I just wanna
No,
make
there's
sure
still
there's.
time left. There's a lot of
Okay.
time left on the case. He's good.
Okay. Do we have a vacation certificate, Myrna, on him? On Mr. Morales?
I need to track it down, Judge.
Hmm. Okay, so the attorney's not appearing. We'll reset him for 2 weeks.
Okay.
Okay. Thank you, Annex. Thank you for reminding us of that.
Thank you, Your Honor. May we be excused?
Have a good, you may. I'm
Thank
gonna
you.
bring in this Sean Johnson. You all are good to go if you don't need to stick around.
Thank you, Your Honor.
Carla, can I talk to you on Teams, please?
Sean Johnson, if you will, please turn on your camera. Mr. Johnson, I see you're muted. This is Judge Perez. If you would please unmute.
Can you see me?
I can. We tried to get you all several messages. Unless you are actually participating in someone's hearing, we do not keep you on the Zoom, okay?
Yes,
The
ma'am.
court does have a YouTube channel. I know Mr. Ivy during the hearing was trying to do the hearing and let you know that, as were we. So in the future, unless that is the reason you weren't brought on in the Zoom and we're
Yes, ma'am.
being removed. Okay, it's the 210 District Court has a YouTube channel. It is on the county website under our court information. All hearings that are remote can be viewed there, okay?
Okay.
Alrighty, thank you very much.
What happened to Kavika?
I'll refer you to his attorney.
Okay. Thank you,
Thank
Judge.
you. Thank you very much. Have a good day.
You too.
All right. Is that everything?
Yes, ma'am.
All right.